Good morning and a warm welcome to today's webinar, Understanding the Uses and Purposes of Irrevocable Trusts in 2023. And I dare say there's nobody better to share this important information with you than today's presenter, Mr. Stephen Elville, Managing Principal and Lead Attorney of Elville and Associates. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. I'd like to start off briefly by thanking the Howard County Library System for their ongoing support of our educational programs and for helping to promote this presentation. Howard County has one of the very best systems in the country, and we appreciate its partnership very much. We encourage and appreciate your general questions today, so when you have a question for Steve, please note it in the questions panel on your screen. We'll take some pauses throughout the presentation to address them. You received the presentation slides by email from me yesterday. To take notes if you wish, the presentation is also available in the section marked handouts in the panel on your screen to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation. And as always, we ask that you please just take a couple minutes to fill out this very brief survey to offer us your feedback about the presentation. And we always read and value every comment that you have to share with us. For our professionals on today's webinar, welcome as well. For CFPs, CPAs, and others, you may receive 1.5 continuing education hours for attending. And if I don't have it already on file, please send me your ID number so I can submit your CE hours for approval and send certificates out tomorrow morning. Here at Elville and Associates, we want to be a resource to you for your families and your planning needs. So consider a consultation or a document review with Steve after today's presentation, and use today's education as a jumping off point to get your planning started or updated. Consultations are the best and most ideal way to get your specific questions answered, have Steve understand your individual situation, and create solutions and a path forward for you. So briefly, I'd like to offer Steve and the firm a proper introduction before we get started. And actually, I don't have the screen pulled up yet. Let me do that real quick. So you should be able to see my screen here. Elville and Associates, we've been here since 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville, who is our founder. We have several different practice areas that we focus on here at Elville and Associates, including estate and special needs planning, estate elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. And Steve and I are coming to you, as always, live from the Columbia Gateway Community location today. Our mission, as always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville and Associates in several ways. Through our planning processes with our clients, we offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only 2 firms in Maryland to have an accredited client care program, or CCP as we call it here, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at the firm. A little bit about Steve. His work as an attorney for the past 20 years, 23 to be exact, I believe, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events, both in person and virtually. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I'm very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to me, and I'd be very happy to share our story with you when we have a little bit more time. But as always, for right now, we are going to talk about something a little bit different, focusing on irrevocable trusts, their uses and purposes. So Steve, I'm going to share the screen with you,
Thank
make you
you,
the
Jeff.
presenter, and we'll get
All right,
started.
I'm going to take charge of the screen. Thank you, Jeff. And I'm going to share my slideshow. And
Okay,
thank you
looks
so much,
good.
Jeff, for that very nice introduction. And good morning, everyone. And happy Wednesday morning to you. I am coming to you from our Columbia location. And I just wanted to, again, thank Jeff for not only all those nice comments and warm welcome and introduction today, but I also want to thank him for all of that he does for Elville and Associates and putting on these webinars, making sure that you can get continuing credit for education and so forth, all the things that Jeff does. So thank you, Jeff. He's an expert moderator. I also want to say thanks to you for being here and spending your very valuable time on a Wednesday morning. Without you, we would not be able to put on these webinars and workshops. So thank you for your support and your friendship. And I hope to reconnect with many of you and to meet those of you I haven't met because of the COVID crisis that disconnected so many of us. So I look forward to reconnecting and connecting with you. I also want to thank all of the attorneys and staff here at Elville and Associates that have helped me to do everything that I have been able to do here at the firm and for clients, including the mentors and other people that I've had in my own life. So it's a beautiful spring day, and we're going to talk about something a little bit different than we normally do. Here at Elville and Associates, we usually give what I would call mini master classes on certain subjects. We really get into the weeds. Today is really not a mini master class. Today, I would say this is more of a mental checklist for advisors and for attorneys and even for clients to even ask themselves, am I really aware and am I making myself aware of all the choices that are available to me in modern estate planning, including these particular types of irrevocable trusts that could help me accomplish my goals. So when you walk away from this today, I want you to have something substantive. We really want to deliver something to you here that you can use and be educated on, but also maybe use this as a mental checklist. As you're working with clients, you're saying to yourself, gosh, I've heard of this particular tool that can be used to help clients achieve their goals. And so that's what my purpose is here today, is to educate, facilitate, and really just provide you with a mental checklist of what's really happening, in my opinion, in 2023 with irrevocable trusts and in planning in general. The other thing I would say to the advisors on the Zoom call this morning is this knowledge is a way, in my opinion, for you to level the playing field. So some of you are quite successful and have built very substantive practices. Others of you are still building and building your client base and so forth. This information is really helpful, in my opinion, to help you, really level the playing field with your knowledge. So with that said, we want to do exactly what I just said and deliver some really substantive information to you today. So I'm going to advance the slides and we're going to get started. Please, by the way, ask questions as we go along, interrupt me. Jeff is very good at this. He'll know when you have asked questions and he'll interrupt me. All right, so with the idea we're going to begin on time and end on time, let's get started. So estate planning in April of 2023. What is my perspective? Well, it could be very similar to yours and what you've experienced so far in 2023. I think that the planning opportunities have never been better. The environment for estate planning has never been better. The exemption amounts have never been higher. Just the utility, just the power that we can bring, let's say, in estate planning has never been more powerful. It's never been better. But from a client perspective, I would say that clients are very on edge. Clients are very concerned. I don't have to tell you, you know well as I do, or if not better, that people are concerned about financial stability. They're concerned about the stability of banks. They're in the U.S. They're concerned about world politics. They're concerned about safety. They're concerned about health care. They're concerned about everything that's happened since the pandemic, and God forbid, what if we have another one? So I find that people are more focused, they are more intense, they are more willing to listen and be helped than they've ever been before. So again, we maybe have a good situation overall for being able to help people, which is their interest is piqued and is continuing to be piqued, and they're willing to take advice, and collaboratively, I'm going to really emphasize this, collaboratively, we have an opportunity as advisors, as lawyers, as CPAs, as financial advisors, as life insurance sales professionals. Whatever our team is going to be, we have an opportunity to deliver at a very high level. And I can just tell you from Elville and Associates perspective, our goal in 2023 is to collaborate with you, with the advisory team, and to form advisory teams in a more proactive way than we've ever done before, and to really bring our communication among advisors to a new level for the benefit of clients. So that's my planning perspective in April of 2023, a really wonderful opportunity to do good in the world and to help people. And clients, of course, as I just mentioned, are very concerned about what they should do, how they should do it, and that's why they should be concerned about what tools are available. What are these tools and how can they use them? We're going to talk about the difference between revocable trusts and irrevocable trusts. So for some of you, this is going to be really fundamental stuff. And for others of you, you may be interested in this. So we're going to cover that. And we're going to talk about the main thing today, which is what are the most common trusts that are available in 2023. I want to say at the outset, this is not an exclusive list. This is just the best list that I can come up with to try to give you a perspective today on what you should be thinking about. We're also going to be talking about what are the uses and objectives of these various trusts, the taxation of irrevocable trusts. We're just going to very much briefly talk about that, and the continuing need for flexibility. All right, so as you are well aware, we are looking at a continuing legislative stasis, I call this. Now, this is a little bit different than the stasis that we had in 2021, where we were very concerned about changes in the laws that would affect irrevocable trust planning. And most of those changes, if not all of them, did not occur. There were no bombshells of taking away the cost basis adjustment at death and many other things, the limitations on grantor trusts. A lot of these things never happened. They may still be on the table somewhere someday, but they're not happening right now. But of course, we live in a divided country, unfortunately, and in many perspectives, in many ways of thinking, that may be causing a positive effect in estate planning, in the sense that there's no talk of cutting the exemption amounts and so forth. So I just want to say that these are good and bad things, but the environment for planning seems to be very robust. The tax rates obviously remain mostly unchanged. The cost basis adjustment at death survives. The use of grantor trusts as a very powerful tool in estate planning largely remains unchanged, and the estate and gift tax rates remain unchanged, although the exemptions continue to increase. We have a $12,920,000 exemption, a $5 million Maryland state estate tax exemption, and these favorable environments, if you're a Maryland resident, continues. So there's new and continued opportunities for basic and advanced planning, okay? Again, we were given this reprieve a couple of years ago from huge changes that could have occurred in the law but didn't. And as I just mentioned, we have these favorable tools that we can use, grantor trusts, life insurance trusts. Back in 2021, there were proposals to take away the power and use of life insurance trusts. And because of the utility of these trusts, they continue to be used, maybe for new reasons, many reasons having to do with the net worth of clients continuing to skyrocket, and with new uses of life insurance trusts as tools for wealth transfer. And of course, we have the ability to continue to think through income tax issues for moderately or middle rich folks. or very wealthy folks compared to our routine estate planning clients. All right, so I'm just going to keep moving through this material. What is the difference between a revocable and an irrevocable trust? So let's just get into this before we get to the types of trusts. So remember, a revocable trust is merely an alternative or substitute for a will. When clients come in and they say, I want to do planning or I want to update my planning, we are talking about a will-based plan, a structure that is driven by a will, or a revocable trust or substitute for a will, and that plan becomes driven by that revocable trust. So we're planning for what happens at death with both of those documents, and we're planning for what happens during life also with powers of attorney, with advanced medical directives, and with the revocable trust itself, which is a living document. So it has some utility there. So the revocable trust is, as a substitute, really just nothing more than a reflection of the grantor. It avoids probate if it's properly funded and aligned. So as an advisory team, we want to make sure we're committed and recommitted to the funding and alignment of assets. But as many of you may be aware, it has no asset protection in and of itself. The revocable trust does not. It has no income tax savings in and of itself. It can be changed or terminated or amended by the grantor, and the grantor pays the income tax. It is a grantor trust. It's the most fundamental of all grantor trusts, where the grantor pays the tax, and therefore it's ignored by Uncle Sam. So how can a revocable trust play into your world? Well, many of your clients have revocable living trusts as these will substitutes. But for those of you who have clients with special needs children or relatives, that supplemental needs trust can also be, and probably should be most of the time, a revocable supplemental needs trust as well. So I'm kind of getting into the types of trusts already, but I wanted to mention that a supplemental or special needs trust can be, and maybe oftentimes should be, a revocable trust as well. Now, conversely, an irrevocable trust, if I were to describe this to someone who had never heard of this, I would say, well, this is not 100% accurate, but I think it gets us 90% to where we want to be. An irrevocable trust is something that is created for a special purpose. I probably have a special purpose, whether I want to do special needs planning and use an irrevocable trust, or a life insurance trust, or a charitable trust, see, or a residence trust. All of these trusts are for a special purpose. So I think that's a good way of thinking about it. Now, of course, an irrevocable trust can be a trust at death. So this is not just an irrevocable trust during life, which is what mostly we're going to be talking about today. It can be an irrevocable trust at death. I pass away and leave a trust for my children. That is a trust at my death, and that is an irrevocable trust there. But today, we're mainly going to be talking about lifetime irrevocable trusts. So these irrevocable trusts avoid probate if they are properly aligned. We could have a irrevocable trust that is not funded. That would not be good, and we would not be able to accomplish our purposes. So the alignment or funding of assets into trusts is important, whether it's revocable or irrevocable. An irrevocable trust can provide asset protection for the beneficiaries if it's properly designed. It can be created at life or death, as I just mentioned, and it can be a grantor trust where the grantor pays the income tax, or it can be a non-grantor trust where the trust pays its own tax, and that's a planning consideration, okay? And it can remove assets from someone's taxable estate, and it can provide income tax advantages. So you see, the revocable trust is a will substitute, basically, and the irrevocable trust is a trust with a special purpose, but it also can be a trust at death that is become irrevocable. Now, the most common trusts in 2023, we want to just look at these initially and get our minds around these. This is not meant to be overwhelming. This is not meant to, just kind of flood our brains with all of these things that are out there that take years for attorneys and advisors to really understand the full impact of these trusts. But this is the initial checklist, so just go along with me, and we're going to get from point A to point B. So we have these death trusts, and you'll notice I'm not skipping over that. These are irrevocable trusts at death. I pass away and I leave a trust for my spouse or child or grandchild or niece or nephew under my will. That is an irrevocable trust, a testamentary trust under my will. I could leave a similar trust at my death from my revocable living trust. Okay, that is a trust at my death. Those are irrevocable. All right, so we've got that one down. Let's now move on to lifetime trusts. So lifetime gifting trusts. Trusts don't have to be called particularly this or that. The trust can have different names because remember, trusts are just entities that are created. Okay, so when I say a lifetime gifting trust, I'm talking about a trust where someone says, listen, I would like to gift assets to my child or my children, but I want them to have some control mechanism, and I also want to have some protection from creditors. So these are lifetime gifting trusts, lifetime insurance trusts, life insurance trusts. These trusts are typically grantor trusts, as we're going to see, but these trusts are used to shield the amount of life insurance from being subject to estate taxation. They also can have other purposes, which we're going to get into. Spousal lifetime trusts, or what is now affectionately called spousal lifetime access trusts. These are slats. These are popular tools to hold assets during life where a spouse contributes assets. We're going to talk about these for the benefit of another spouse. And you're going to find out today that these lifetime slats or these access trusts are basically lifetime bypass trusts or lifetime family trusts for those of you from the old school. So this is something we're going to talk about today. Charitable trusts and all the wonderful things that can be done with them for someone who's very intentional, someone who's very charitable minded. Medicaid and Veterans Trusts. Arguably, the Medicaid Trust is one of the most powerful tools today. Sometimes we don't really want to call it a Medicaid trust because sometimes it's not used for that purpose. So we might call it a 5-year trust. So the 5-year trust versus a veterans trust in elder care planning and sometimes not in elder care planning for the benefits and uses that those types of trusts provide. I just talked about a bypass trust, so a marital trust versus a bypass trust. These are how assets are left at death or during lifetime for surviving spouses. So we're going to get into that a little bit. The grantor retained annuity trust, or GRAT. This is a technique to remove assets from the taxable estate. We've talked about special needs trusts so far a little bit. We're going to get into more of the weeds on that. A minors trust or an education trust. Dynasty trusts, what are those? Okay, how can we make a trust, no matter how sophisticated it may look or not, how can we make that trust dynastical? Okay, domestic asset protection trusts. So see, we're going all around the world here. What in the world is that? Well, that is a DAPT, a D-A-P-T. And there are various types of these. There are hybrid DAPTs. There are what I would just call conventional DAPTs, which are not that effective. These are asset protection trusts domestically in the United States. We're going to talk about that. Special power of appointment trusts. These are maybe a version of a DAPT that really goes one step beyond and ratchets up the asset protection to where it really should be. People that do these kinds of trusts, they expect asset protection. They don't expect that it will not work. And these kinds of trusts are appropriate for someone who's willing to jump through the kind of hoops that are necessary. So we're going to talk briefly about that. Community property trusts can be established in certain states, even if you don't live, even if your client doesn't live in a community property state, such as California or Texas. So these are interesting trusts for the right kind of client. The qualified domestic trust, this is the trust for a non-US citizen who is also engaged in planning. Qualified personal residence trust. This is a trust used to discount the value of a residence. So some people use those. A crummy trust. This is a trust where It could just be a life insurance trust where we are using the crummy annual exclusion power to be able to get money into a trust without using our exemption amount. Quiet trusts, some states have quiet trusts, Maryland does not, and a standalone retirement plan trust. So that's a mouthful as we get started. Jeff, before I really launch into the substance of the conversation today with these trusts, I just wanted to stop very briefly and see if there are any preliminary questions before I launch in.
Thanks, Steve. No preliminary questions for right now.
All right, thank you. Okay, and the highest and best use of our time, I'm going to launch right into trusts at death. So as we go through our list, mark this up, use your tablet, use whatever device that you have to be able to make notes. So these are trusts at death, and as I mentioned, they're irrevocable. They can be left under a will. They can be left under a revocable trust. They can even be left under an irrevocable trust. There could be an irrevocable trust established for a special purpose, and then at the time that trust terminates and it maybe is paid out to further trusts, those trusts can be irrevocable and continue on. So these are trusts at death. These could be a marital trust. It could be a Q-tip trust, a qualified terminal interest property trust. It could be a bypass trust. This is a technique of, am I going to leave assets to the marital share upon my death if I'm married, or am I going to leave assets to the non-marital share? So this is a planning consideration. It's going to depend on the goals of the client. It's going to depend on the size of assets. These are further trusts, as I mentioned, for the control, protection, and management of the assets for children, grandchildren, nieces and nephews, others. And these are non-grantor trusts. So when we leave these trusts at death, these further trusts, they're going to be non-grantor trusts, trusts that pay their own income tax, not grantor trusts like we've been discussing a few minutes ago. Now, let's skip now to lifetime gifting trusts, or what I might just call an irrevocable trust for the purpose of receiving gifts. And of course, there's various uses for these trusts, but these could be trusts for spouses, children, grandchildren. And the issue here is really just deciding what purpose. So our client is really going to decide, what is their goal? What is their objective? And if they can just describe this objective, right, we can help them get from point A to point B. So when we are using these trusts for lifetime gifting, okay, then there's lots of reasons why somebody would do this. And I don't want to be exhaustive in this conversation about a lot of general things that may not be really meaningful in these descriptions. But just know that these could be gifts for a spouse. And let's just start there. A lifetime Q-tip trust. So many of you may have heard of this, but lots of you may not have heard of this. This is an underused technique. So let's say that someone, if they had died, they would leave assets, like many people do, to a marital trust. And we would just maybe call that a Q-tip marital trust. The assets are going for the benefit of the surviving spouse. Well, many people are not aware that that same technique can be used during lifetime. And in Maryland, for example, if this lifetime Q-tip trust is established and funded for a spouse during lifetime, it can provide very, very significant asset protection for that couple, for that spouse, even though Maryland is not what I would call one of the asset protection states. So a lifetime Q-tip is a very, very important trust concept for you to be aware of. It can be done during life of a couple. A grandchild's trust obviously could receive gifts. An education trust. It could be that there is a charitable trust. I have a person right now who makes contributions on a quarterly basis to a trust that's really designed to go to charity, but that is his goal. These trusts could be made dynastical for the beneficiaries, meaning it is a trust that is receiving gifts, let's say for a grandchild, but it's meant to last in perpetuity at the grantor's death. So sometimes grantors will, or donors will give small gifts during lifetime or substantial gifts during lifetime to a gifting trust. And at death, they intend to establish a further trust for that grandchild or whoever the beneficiary is. Well, through the doctrine of merger, if that were the case, these trusts can be merged into one trust, providing that everything is similar in the terms and provisions of the trust. So just try to spark your imagination about the use of these types of trusts. And if your client says, hey, I'd really like to, gift some assets, I've got a lot of cash, or I'm trying to lower my estate tax liability for Maryland purposes, for example, because Maryland has no gift tax. There's all kinds of reasons why someone would want to do this. There also are lifetime reasons why someone might gift annual exclusion gifts into a life insurance trust for purposes of getting assets out of their estate. But I digress a little bit, and we're going to get to that. And these trusts can be established as grantor trusts or non-grantor trusts. So what is the advantage of the grantor trust? The grantor pays the income tax, thereby increasing the amount of the gift and thereby decreasing the amount of maintenance that the donee, whether that's a grandchild or whoever that is or child, is having to bear the burden of. Now, speaking of life insurance trusts, these tools remove the value of life insurance from the estate of the grantor. They are used to do all kinds of wonderful things, but they are mainly, in my practice right now, used to lower estate tax liability, okay, to bolster supplemental needs trusts, because sometimes we need a funding mechanism for that, or to deal with the onerous aspects of the Secure Act, where people with large IRAs and their non-Roth IRAs are facing huge tax liabilities for their children, and they want to use life insurance as a tool, as a wealth transfer tool. So those of you on this webinar that are experts in life insurance, I know I'm preaching to the choir, but just for those who don't know this information, this is this wonderful tool, and it can be used for first to die policies or second to die policies. It provides for control for the person who is the grantor, where they can be assured of what's going to happen. And if it's properly designed, there can be some benefits to the grantor, even though the grantor has basically given up control of that asset, of that trust. And that trust, of course, owns the life insurance, and that trust is the beneficiary of the life insurance. It provides asset protection for the beneficiaries if it's properly drafted. And as I mentioned just a few minutes ago, it can be used to leverage gifts. So let's say that someone had a premium on their life insurance of $10,000 a year, or whatever it was, $5,000 a year, $30,000 a year, sometimes even bigger. And that person had many beneficiaries. They had children, they had a spouse, they had grandchildren, and they wanted to make gifts to the trust. Well, they can leverage those gifts using their crummy powers to be able to provide annual exclusion gifts to the trust. And through the proper design of the trust, it's possible to gift much more into the trust than just the amount of the premium. So the grantor can use the life insurance trust as a gifting tool if that is one of their goals. And as I just mentioned, it is a tool to deal with the Secure Act, future growth of the estate, all kinds of issues that crop up as people are getting older and wealthier. These trusts have their utility. And typically, but not always, but typically, these trusts are created as grantor trusts for income tax purposes. Okay, I'm going to just take a little bit of a pause here for a drink, but now we're going to shift to a different type of trust. This is that spousal access trust we call the SLAT, the Spousal Lifetime Access Trust. This is that tool that many of your clients have used over the past few years and may continue to use to basically transfer exemption amounts, meaning large amounts of their 12,920,000 exemption into a trust. And if it's obviously, it's mostly for married couples, and this is usually done in a reciprocal way, but I don't want to use that word too literally, because we certainly don't want reciprocal trust, and we actually have to be very careful not to have a reciprocal type of arrangement. But what I meant to say is that it's done usually in conjunction, not always, usually in conjunction with gifts of the other spouse as well, but not always. It depends on the size of the estate. So if we look at our exemption amounts as temporary, meaning that they will adjust in 2026 based on the legislative agenda, then we want to encourage clients with proper counseling and with the proper knowledge, okay, that there's going to be a loss of step up in basis. There's not going to be a cost basis adjustment, that there is going to be this gift away from the donor spouse, and that spouse has to be able to live with this. And it's going to provide creditor protection. That's a very good thing. But all things considered, the loss of control, whether or not the grantor will be or can be added back as a beneficiary later, whether or not these things are going to be really in coordination with the client's goals, all of this with proper counseling means this is a powerful tool for the right person. So we have to make sure proper counseling, proper tax advice, and this is where I think the advisory team comes in at a very high level for a client who's considering this kind of planning. For certain clients, this is going to be straightforward. It's going to be a no-brainer kind of thing. But again, the mechanics are critical. The counseling is critical. And these trusts are grantor trusts for income tax purposes. The charitable remainder trust. So now we're switching. See, so we're not getting too far into the weeds on any particular trust. I'm wanting you to use this presentation as a mental checklist. So the charitable trust is an irrevocable trust. There are variations on this. For example, a charitable remainder trust. The charitable context is very large, and we're not going to be able to get into all aspects of charitable trusts. So if we could just take this one example, just to remind ourselves that we can create for our clients opportunities with charitable gifts. Now, charitable trusts are not always the right answer. They're not always the right approach. Sometimes a straightforward gift or a straightforward beneficiary designation where the assets are going from point A to point B. Sometimes this is the most viable and most efficient way of doing things. But for the person who wants to have an income, or for their spouse to have an income, their children to potentially have an income, and also have a charitable remainder, and also a current income tax deduction for having made this charitable contribution to the trust, this can be a very powerful tool. Now, of course, the person has to have charitable intent. For example, this is one of the very limited number of ways we have of dealing with the Secure Act. This is a strategy under the Secure Act to be able to, not really under the Secure Act, but to deal with the Secure Act, having to do with giving children somewhat of a stretch out while still accommodating charitable intentions, okay? But if the client does not have charitable intentions, obviously, then the charitable remainder trust is just not going to work in that particular case. So the main use of this trust is to be able to contribute low basis assets where someone is very charitable minded, and to be able to sell those assets inside of the charitable trust with no capital gain. And so that's really the purpose here, again, for the person who's very, very charitable minded, and this is a non-grantor trust. So let's just remember that our clients are more wealthy than ever, generally speaking, in my opinion. And they are, many of them want to do good in the world, and we want to keep our charitable trust and our charitable strategies at the top of mind. Now let's talk about something that we're going to be talking about in about a month or so at our advisor forum. We're going to drill down into the 5-year trust and what it's really about. But this is just a surface explanation of the Medicaid / 5-year trust or the Veterans Trust. This is a popular tool for elder care planning, but again, it's also a tool for some wealthier clients that kind of want to have their cake and eat it too. And I'll explain what I mean by that. So this is used as a control mechanism. This is something where a person makes a gift to a grantor trust. And again, this is on the Medicaid planning side or the 5-year planning side of the fence, okay? And this person is able to do this if this trust is properly designed and there's no loss of step up in basis. The grantor can retain some limited control, even though they've really given away the assets, and this is very appealing to a lot of people. And what's also appealing is that they can give this asset away to an irrevocable trust. And if one of the beneficiaries gets sued or divorced, God forbid, this trust protects the assets that were gifted from the claims of beneficiary creditors. So this is a big thing when a grantor is giving up control of assets for elder care purposes, or just because they wanted to use a trust where they could still maintain some control and have some of those features available. A good example of this is I was talking to a client yesterday who's quite well off and will probably never need Medicaid, or certainly will not need veterans benefits. But she's interested potentially in using a 5-year trust to be able to have the best of all worlds. Her fear, which is probably unfounded, is that she will run out of money someday. And with a 5-year trust, the money could be used through a backdoor technique, could be used for the benefit of the grantor. So again, these are trusts that are designed for special purposes, very powerful tools for the right client. And I would say this is for the middle rich or moderately wealthy client, and for routine clients that are not of significant wealth. This is still a viable tool for anything in that genre. And the Veterans Trust is an offshoot of the 5-year trust. In 2018, the VA changed its rules and made the obtaining of veterans benefits somewhat more difficult. But we find now that all of those cobwebs have been worked out. So when someone wants to divest themselves of assets for elder care or veterans purposes, or even for just general purposes due to the advantages of these trusts, these two types of trust can be used, and we have to be careful about which one we think is better. Now, just continuing on, and I think we're doing very well on time, Jeff, talking about the marital trust now. So we're all over the place. We're going all around the world here. Gifting trusts, life insurance trusts, slats. We've talked about all of these types of things. Now we're talked about the long-term care planning trusts. Now we're talking about marital trust. So this is a very popular tool in spousal planning. I mentioned this just a few minutes ago. So if we looked at things at a very high level, we know that most couples, if they are married, leave everything to each other either outright or they leave assets in further trust. Why would someone do that? Well, if you look down these bullet points, it says, well, first of all, if I leave assets in further trust for my spouse, I'm controlling that from the grave, but I'm giving my spouse asset protection. Because when we were living, we were spouses, and we were able to have the benefits of tenants by the entireties, which is the basic asset protection form of ownership for spouses. Now, tenants by the entireties is not all things to all people. It does have its limitations, but it is a good foundational tool, the tenants by the entireties. And I would encourage all the financial advisors on the Zoom call this morning, this webinar, to please look at your client's assets and try to get, where appropriate, try to get many of those assets into the tenants by the entireties form of ownership. Now, we don't want to take assets out of the name of one spouse where they have never owned those assets jointly and those assets have low basis. We certainly don't want to do that willy-nilly. But for assets that are joint and they're just sitting there in a brokerage account, jointly owned with no tenants by the entireties protection, that's an opportunity to add value and protection. But now in this context, one of the spouses has passed away, and they say, well, I'm either going to leave the assets outright to my surviving spouse, or I'm going to leave assets in a marital trust so that I can give my surviving spouse asset protection in those assets that they would not have had if I had just left them outright. And I'm also protecting for remarriage purposes. So that's beyond the scope of today's discussion, but many people are concerned about protecting their ultimate beneficiaries, their children, So leaving assets in a marital trust may be desirable to protect from remarriage and those issues. So this is a powerful tool. I would say many people with proper counseling are going to want to use this technique. It is not simple, just as simple as leaving assets outright, but it is a powerful tool. And as I mentioned a few slides ago, this technique can also be used, during lifetime, to have a lifetime Q-tip trust. So remember, the surviving spouse has to get all income, at bare minimum, all income. But many of these trusts are designed where the survivor gets income and principal. So just because of the large exemption amounts that we have and the nature of the tax laws right now, that there will be a step up in basis to the surviving spouse on non-retirement assets, and a second step up because we're using the unlimited marital deduction, a second step up at the death of the second spouse. The use of a marital Q-tip trust, if properly done, will maintain that double step up in basis. So that's why 85 to 90% of people in this country are going to plan either for outright distribution or distribution into a marital trust where those two goals, asset protection and spousal protection, are desired. So that's why this is a very popular tool, and you should be familiar with this. Now, conversely, the bypass trust is really a fancy way of saying leaving assets to a non-marital trust. And this is the same technique when you think about it on a broader scale as the SLAT. The SLAT is really a lifetime bypass trust, whereas I'll go back one slide, the marital Q-tip trust is obviously a lifetime marital trust. So we have a lifetime marital trust, we have a lifetime bypass trust with a SLAT. But here what I'm talking about is one of the spouses has died and they have not left assets to the marital share per se. Maybe they left assets to both, but they are using, in my example here, a non-marital trust. Now, this is a popular technique, although not as popular as the marital trust. There is a lot to cover here for this kind of trust, so I don't want to be too simple about it. There are very complex treatises written about marital trust and bypass trust. I'm just giving you the very basics today. Some of you who have been around a while will recognize that a bypass trust might be called a family trust, or it might have various residuary names like credit shelter trust. So we're talking about the same thing here, no matter what term of art that we're giving it. So it does provide the same thing as the marital trust as far as asset protection and marital protection. And I would argue it gives more marital protection probably than the Q-tip trust. I think we could argue that. It can have more restraints on it, such as restrictions on marriage, in my opinion. But it does not give a second step up in basis, just like when we are using a lifetime bypass trust, which I just called a SLAT. We're giving up that cost basis adjustment. So there's a first cost basis adjustment at the death of one spouse, but not a second one when the surviving spouse dies 30 years later. But again, it does provide asset protection. It does provide remarriage protection. It provides the control, okay, that spouses are looking for, and these assets will flow down to the ultimate beneficiaries. So I just want to plant the idea in your mind that when clients are doing planning, it's going to be basic planning, outright distribution or distribution into a marital trust, or distribution into a bypass trust, the non-marital trust, or a combination of both. And that is planning, and the goals of the client are going to drive that. Now, the grantor retained annuity trust, and I'm just going to encourage you now to take a drink of coffee or start eating your lunch if you're an early lunch person, to really just kind of stay focused here. This is a lot of information. I'm doing a lot of talking. You're doing a great job of being here with us today, so thank you for hanging in there. The grantor retained annuity trust is not going to be the kind of tool that we can really do, let's say, huge exemption planning. We can't just, get assets, tons of assets out of the grantor's estate very quickly, like we could with gifts, with slats, and those kinds of things. This is more of a strategy. This is a gifting strategy where we're doing a what we would call an IRS interest rate play to remove assets out of the grantor's estate. So with your wealthier clients, this is going to be a powerful tool. It is definitely powerful. It is definitely something that can really be wonderful, but it is not something that is going to be getting assets out of the grantor's estate in large amounts in one fell swoop. So we just want to be aware that this is a strategy for wealthier clients. It can be complex. The numbers can be complex, and you have to run these numbers. And this is where I would encourage the collaborative team to really be on the same page as with all of these strategies. Now, a minor's trust, I don't see too many of these, but these can be used. The beneficiary has no crummy withdrawal rights. These are just matters of design. These are mentioned in the code. So this is just something you need to be aware of if your particular client is interested in such things. An education trust is a tool for parents or grandparents. Lots of grandparents like to do this. And this can be done, of course, in a standalone lifetime trust. It can also be a trust under a will or revocable trust. And of course, many of you are experts on 529 planning, and you're going to, as well as the clients, compare this kind of planning to 529 planning. And as I just mentioned, this could be implemented during life or at death. And depending on the grantor's goals, this can be multi-generational. It can be very significant rather than just kind of a temporary educational trust for a limited number of people. For example, the current grandchildren. This can be multi-generational and have a philanthropic flair to it, where the grantor intends for there to be lifetime educational trusts for lots of people down the generations. So the tax treatment of this is going to vary depending on the goals of the grantor. Some people I have worked with, their vision of this kind of trust is such that we're not going to be able to maintain some of the traditional tax advantages, and the client, as long as they're informed, they may be okay with that because their goals are let's say, more driving the program than the tax planning. But again, these are very important to clients, and they can be standalone or they can be included in wills or trusts. Now, special needs trusts, I've alluded to earlier. This is an essential planning tool for people with disabilities or chronic illnesses. And the Secure Act specifically says that people with disabilities and people with chronic illness are exempt. And if IRAs are left to the special needs trust, or what we would call a supplemental needs trust, then that IRA is going to have the eligible designated beneficiary label, and it's going to be able to pay out over the lifetime of the beneficiary. So this is a wonderful tool. It seems to be proliferating more and more. And even though it is not one of the more complex trusts, I think that this is a wonderful thing for you to know about because of the proliferation of autism and disabilities in this country. People with disabilities, whether they're young or old. So remember, your client who has a child or a loved one with special needs, that special needs trust is an eligible designated beneficiary itself. And the person with chronic illness, their special needs trust or supplemental needs trust is an eligible designated beneficiary, not just the person, but their trust as well. And we want to make sure that trust is drafted right. When I was a young lawyer, we drafted all of these trusts as irrevocable. That is how I was taught to do it. But now in recent years, the last 10 or 15 years, supplemental needs trusts can be drafted as revocable for convenience and for not having to file a separate tax return, or they can be established as irrevocable trusts. But they are irrevocable no matter what at death, they must be. And of course, they must be irrevocable when they receive an IRA. These trusts protect the means-tested benefits of a beneficiary. Means-tested benefits are SSI, supplemental security income related benefits, where the person cannot have more than $2,000 in their name. They could be waiver benefits, For example, DDA waiver benefits, the autism waiver, where someone is receiving substantial waiver benefits because of their disability, and that waiver program is a means-tested benefit. So that's what these are about. However, in my opinion, and some people would disagree with me maybe, there are times when someone is disabled, they're not on means-tested benefits, but it's still appropriate to use a supplemental needs trust for that person because of how that is structured. Now, remember, if that person is not quintessentially defined as disabled under Social Security, they won't necessarily be eligible as an eligible designated beneficiary. But nonetheless, a supplemental needs trust still might be the appropriate tool for those individuals who are disabled that don't really fall into any particular clear category. So we want to be aware that these are tools for means-tested benefits protection, but many times for just ancillary uses for people who are possibly not on means-tested benefits. And this is a lifetime management tool. And the bread and butter of special needs planning is the supplemental needs trust. We call that a third-party supplemental needs trust. The parent or grandparent or another third party is establishing this trust and funding this trust, whether it's life insurance, IRAs, non-retirement assets, whatever it may be. The first party trust is the trust that is designed where a person actually receives money that they shouldn't receive. It disturbs their benefits, and that money has to be taken out of their name. So if you have not heard of this, there are two types of first party trusts. We will not be able to get into all of this today, but just be aware that this is a powerful tool for a person, especially a person who's under 65, where their lives and their benefits were disrupted, but now that money can be taken out of their name and still put into a special needs trust. And just a tidbit for those of you who really like the true details, the first party trust is the only trust that I am aware of where Uncle Sam will allow an IRA to be retitled, not just beneficiary designated, but retitled into the name of a trust with no taxation. So if you have a client or a relative of a client who receives an IRA from another person, now this is not their own IRA, this is they've received an inherited IRA and they should not have, that IRA very likely, private letter rulings have said this, and a person can request their own private letter ruling depending on the size of the IRA. That money can be moved into a first party trust with no taxation.
Hey, Steve.
As I just mentioned, go ahead, Jeff.
Can I ask you a few questions?
Yes, please.
Okay, great. I have a few good questions here from our attendees that just came through. And the first one is from an advisor friend of ours here. And he says, in your experience, Mr. Elville, have you seen people create different trusts for different reasons by putting some assets into one trust and other assets into another? Or do multiple trusts invariably compete with each other on legal terms?
Well, that's a great question. Thank you for that. And thanks for attending today. I would say I need more information to truly answer that, but I think it's entirely feasible for someone to have multiple trusts because of everything was goal driven, and these trusts satisfy a goal. Okay, so I don't think it's necessarily duplicative to have several lifetime trusts. But of course, we have to look at what those trusts are doing and do they compete? Are they unnecessary in the sense that nothing's really being accomplished by having all these excess trusts? So I do think that there's no reason to believe that a person can't have multiple trusts and that they're all beneficial. It's just we would have to make sure on the back end that they're not competing or they're not duplicative. I think that's a wonderful question. That I think it's possible, and it's also possible that they are duplicative and that maybe something needs to be changed. But I think generally the answer is yes, that can be the case.
Okay, next question. Very beautifully presented. My question is, as a mother of a 21-year-old autistic son who has had Medicaid since 2 years ago, currently he is not employed, and I'm a layperson to all these subjects. What sources do you recommend for me to read and get more information? Thank you very much.
Thank you so much for that question and for your kind words. I would say you should probably go to, you could go to our website and read about special needs trust. That's one of the first things you could do. One of the second things I would, not just because we have done these, but I would go to our website, or Jeff can send you a link to planning for a loved one with special needs or with disabilities. I think that's going to give you a lot of background information to watch that webinar. It's an hour and a half, but if you have the time to watch that. I think another thing you can do is you can go to a website such as Elder Law Answers. Elder Law Answers. This is a website out of New England put out by a friend of ours named Harry Margolis. And Harry has been doing this for years and years, and I think you could find a lot about special needs trusts on that website. There are internet resources at the Academy of Special Needs Planners, but I think before I would go there, I would go to those other ones and Elder Law Answers.
Thank you, Steve. Yes, Saba, I will go ahead and send that information to you. And last question is, what happens at death of a special needs individual?
All right, thank you for that question. It depends on the kind of trust. If it's a third-party trust, and thank you for that question because that's right on the next slide that we have here. So that third-party trust, this is going to answer your question, is the bread and butter of estate planning for special needs. So there is no payback to the state. So by having done that good planning, that proper planning, upon the death of the beneficiary, the person with disabilities, there is no payback to Maryland because this is a private third-party trust. It can go anywhere that the grantor says the money should go, to other descendants or whatever the design is. And I will say along these lines that one of the late and great changes that has occurred in late 2022 was that IRS, for reasons that are beyond today's discussion, was discouraging and not allowing a special needs trust to designate a charity, which many families with loved ones with special needs love to give to, not all, but love to give to charity, maybe to the same organization that benefited their child or loved one. But the IRS said if you list that charity as an ultimate beneficiary, you're going to destroy the tax deferred stretch out of the beneficiary under the Secure Act. But now the good news is that has been removed. So part of the answer to your question is there's no payback to the state. It can go to any person or organization that the grantor chooses, and that's the newest law. But if it's a first-party trust where this disabled person received funds, those funds were something that had to be moved out of the person's name, there is a payback to the state of Maryland. So the first thing that would have to happen is it would have to be paid back to Maryland for any amount of benefits that had been paid for that person. And then the balance of any assets could be going to other family members. So that's the difference between the third-party trust, no payback, and the first-party trust, which is a payback trust. And thank you for that question because that helped me cover the slide that I was on there. All right, in the interest of time, I'm going to keep moving. Thank you for your wonderful questions. A dynasty trust, in my opinion, is nothing more than a bloodline trust. Now, you're going to hear lots of names. It's going to be called a GST, or generation skipping trust, a dynastical trust, a multi-generational trust. So these are trusts that are designed to stay in this funnel, in my opinion, just for purposes of today, that drive down to family members for generation after generation. And these assets can be created as a lifetime trust. So some of the more sophisticated dynasty trusts are created during lifetime, such as a Maryland trust that is a dynasty trust, or a Delaware dynasty trust. These are trusts that are designed to last forever under state law. There is the rule against perpetuities. For example, Maryland has none, so these trusts can last forever. This creates asset protection for beneficiaries from the claims of creditors. It limits the control, of course, of the further beneficiaries, and it freezes the assets for estate tax purposes. So the person who establishes this dynasty trust, Uncle Sam looks at their generational level and says, can we get some tax from this person? And whether or not there is estate tax at that level is a question. But once these shares are funded into the dynasty trust, they are never taxed again for estate tax purposes, okay, with a couple of rare exceptions. And the generation skipping tax has to be allocated. The exemption has to be properly allocated. And there are issues for generation skipping tax, and there are issues for capital gains down the road, but generally not for estate tax ever again. So these trusts can last forever depending on the jurisdiction. Domestic asset protection trust, we talked about this briefly at the beginning. So there are about 18 or 19 asset protection jurisdictions in the state. We live right next in the United States. We live right next door to Delaware. We work with many Delaware attorneys. We work with Nevada attorneys, Alaska, South Dakota, whatever the jurisdiction is that is desirable. And these asset protection trusts may, and that's a big word, may afford asset protection to the trust settlor. And these are usually designed as dynasty trusts. And there are versions of these. There are hybrid versions, which these lawyers will tell us, generally speaking, these are more protective. The hybrid versions are more protective than the self-settled version. So you can go, or your client can go to one of these states and actually self-settle a trust. Now, you cannot self-settle a trust in Maryland and have asset protection because we do not have those kinds of laws, but you can in those states. But nonetheless, even though a person can self-settle a trust, that doesn't necessarily mean that that is kind of a bulletproof wrapper around those assets. So the hybrid DAPT and the special power of appointment trust are tools that are more powerful for protection than just the typical traditional self-settled domestic asset protection trust. So I think part of good counseling is making clients aware of these particular tools that are available, and then if they are appropriate, to work with the out-of-state counsel to make sure people get the kind of choices and options that they need for their goals. A community property trust is a trust that is obtaining what? A 100% cost basis adjustment at death. So without getting into all of the various details, with a non-community property state, unless assets are in the particular name of the person who dies, let's say someone has $10 million of stock in their name that they paid $1 million for, that person is going to get a 100% cost basis adjustment at death because they owned that stock, that low basis stock at their death. But if that person owns joint property, they're not going to get, in a non-community property state, they're not going to get a 100% cost basis adjustment. So for the right client who has low basis assets of a very large amount, and where it might be advantageous to have to pay a trustee in another state. And this list, I apologize, I didn't necessarily update this last bullet point here. We know Alaska, Tennessee, and South Dakota have laws that allow for a community property trust, even if you don't live there, even if the property is not in those states. That list may have grown by now, and I apologize, I didn't necessarily update that list. But this is a technique where a person who does not even live in these jurisdictions, who doesn't live in a community property state, can have a trust under the laws of that state that will achieve a cost basis adjustment of 100% as if the person lived in a community property state and actually had the property in that state. So this is something you as advisors need to be aware of. It exists, and it's a potential tool for the right client. A qualified domestic trust is for a non-citizen surviving spouse. It allows the non-citizen surviving spouse to use the unlimited marital deduction. And of course, it's much better if the non-citizen spouse, when you're doing planning, it's a great thing I love to hear is that they're becoming citizens. It's not great to have to do this kind of planning, but you have to do this if you want your surviving non-citizen spouse to be able to use the marital deduction. It protects the U.S. government. Uncle Sam does not want the non-citizen spouse to be able to move out of the country and avoid taxation on worldwide assets once there is a deceased citizen spouse. So this is just kind of basic planning for non-citizen spouses. And if you're not familiar with this, this will at least familiarize you with that aspect of planning. A qualified personal residence trust is a tool. I don't see it used as much as I used to see it. And in the environment of large exemption amounts and the ability to exempt nearly $26 million from federal estate tax, many times this is not really what our clients are going to do, but you need to be aware that for someone who has a second home, for example, as a prime example, that person can gift that home into a trust and they can freeze the value and they can discount the value of that residence for estate and gift tax purposes. It has a little quirk in that if the grantor survives the period of the trust, they have to pay rent. So many grantors don't want to have to pay rent for their own house, but this is a way for the right person to be able to discount the value of their estate when they have exhausted other methods, or maybe this is part of the repertoire of discounting to the taxable value of the estate, so that even though the gift was X amount of dollars, for federal estate tax purposes, the value of the residence has been reduced because this is called a split interest gift. And of course, we talked about the crummy trust. And for those of you who need a good story to tell your clients, I would look up the Mr. Crummy on Google, and I would read about his case, which I believe was in the 1960s, and all of the children and grandchildren he had. And the IRS had to agree with him that if he were to make multiple gifts into his trust using the annual exclusion amount, and he makes those gifts present interest gifts. He actually gives the person who is the beneficiary the actual right of withdrawal. Now this annual exclusion gift qualifies and he can get money in that trust. As I mentioned earlier, getting money into an irrevocable trust in large amounts without having to use the actual exemption amount. So this is called a crummy right. The crummy notices have to go out. This has to be carefully documented because someday we're going to have a stronger and more scrutinizing IRS. So this is the crummy power. The annual exclusion amount is $17,000. The folks at Heckerling tell me this is going to go up to $18,000 next year. So just know that this continues to go up and this remains a very viable tool and power, even though many of our clients have large amounts of money and the exemption amounts are very large. Quiet trusts, as we're almost finished. Maryland does not have a concept of a quiet trust. Beneficiaries in Maryland are entitled to information and notice since 2014 under the Maryland Trust Act. So if you have a situation where your client and their beneficiaries are not necessarily on the same page, and it's not desirable for that beneficiary to really have a lot of information, we probably don't want to use a Maryland trust because there are arguments back and forth on this, but in my opinion, and I think in the most attorneys' opinions, there is no way to prevent a beneficiary in Maryland from receiving the information they are entitled to as a qualified beneficiary of a trust. So just know that some states like Delaware do have things called quiet trusts, and it's something that you can explore in your particular situation if it's appropriate. Standalone retirement plan trust. I think we're at the very end. Thank you for your time and attention. This is a tool that may or may not still have viability depending on your view, depending on your client situation. Prior to the Secure Act, this was used as a funnel. This was used to segregate retirement plan trusts, or excuse me, retirement plans or retirement plan assets from non-retirement assets so that a beneficiary that we wanted to protect. So remember, we have to use an irrevocable trust if we want to protect a beneficiary who's receiving an IRA. Otherwise, we can just assume there is no asset protection if that beneficiary receives an IRA outright. So if we leave it into a trust, we are either going to leave it into a trust that has retirement and non-retirement assets mixed in together, which we can do, as many of you know, or we can segregate the retirement plan into a separate trust. So this is just a question of intent on the part of the grantor, and it's a question of the size of the IRA. If it's a very large IRA, perhaps we want to use a standalone retirement plan trust to achieve the purposes that we're looking for asset protection and basically encouraging the beneficiary to keep those assets segregated and not make them available to a divorcing spouse or other creditors. Now, with that said, the ramifications of the Secure Act now make this more difficult, because holding IRA assets inside of a trust long term, where no stretch out is available for the typical designated beneficiary now, meaning 98% of people in this country who are not eligible designated beneficiaries, having those assets tied up in an IRA is going to cause massive taxation. So that's probably not going to be desirable. And with the 10-year payout rule, assets that are held in trust probably are still going to be paid out of the trust in 10 years. So this is a counseling issue. And of course, there are times when someone might say, well, the onerous taxation is still part of the price I'm willing to pay to protect these assets inside the shell of the trust, so that the beneficiary does not have outright distribution of the assets. There are going to be limited times when that is the case. So I would say leaving assets in a standalone retirement plan trust is arguable one way or the other, more so than it was in the past, as far as whether that is a good technique. But that is available, and we need to realize that these kinds of trusts do exist, and they are irrevocable, because it has to be irrevocable when it receives an IRA. Now, real brief taxation overview. We know that revocable trusts are grantor trusts. We know, for example, that life insurance trusts are grantor trusts. And this becomes very confusing for a lot of people. Keep it simple. If the trust is a grantor trust, what do we know? The grantor will pay the income tax on their own tax return. So revocable, life insurance trust, these are basic examples of a grantor trust. The grantor trust rules are in the code, so there it is for you to see. Non-grantor trusts, the trust pays its own tax. These are typical spendthrift trusts at death. This is the trust that you left for your child or grandchild at death. That's a non-grantor trust. It pays its own tax. A charitable trust is a non-grantor trust. And then tax reporting. Many of you on this webinar prepare taxes and you understand this concept, but if you haven't seen this explained, it's very important, if you're doing trust planning, to understand taxation and how distributable net income is carried out to beneficiaries, how capital gains should be managed, and how the trustee and the financial advisor and the CPA need to work together to manage trust taxation. So that's a webinar in and of itself, but just know that the concepts are grantor versus non-grantor trust, and the concepts of D&I, how assets are distributed out. And for those of you with special needs trusts or children or grandchildren, it's very important for you to understand how income tax is treated, or income, I should say, is treated to your special needs loved one, and how they basically end up paying the tax. And this is something to illustrate at another time, but it is not income for Medicaid purposes. So just because your special needs loved one receives income from a trust and is attributed the income from a trust for their own tax return, which is a strange concept, it does not mean that they're going to lose their benefits, because that is not income for Medicaid purposes to that beneficiary, because it came from a special needs trust. Flexibility, as we wrap up, that is the key today. If I could drive home one thing to you other than this checklist of different types of irrevocable trust, it would be many older trusts have no flexibility mechanism. They don't have trust protectors. They don't have special independent trustees. They don't have distribution advisors and all of these modern techniques. And so what I would encourage you to do, if you have an older irrevocable trust or your client has one, we should probably review it and say, is there any way that we can modernize this trust? And there are techniques to do that. If you have a newer irrevocable trust we're dealing with, we want to make sure that it provides for the same kind of contemporary flexibility, which generally is very desirable, especially at least having a trust protector, a person who can, an independent fiduciary who can amend a trust or remove the trustee and so forth. The power of attorney document can be very, very important in providing, even though that has nothing to do with an irrevocable trust, it can be very important in providing flexibility to be able to create irrevocable trusts or to fund those trusts. And lastly, we all need to be aware of a concept called decanting. This is the ability to change a trust completely from this form to this form, a new trust. So this concept is beyond the scope of today's discussion, but flexibility is something that you need to be aware of that exists today. And the question is whether the trust actually has these features built in and whether state law allows for these kinds of things. But generally speaking, the state law is going to look to the terms of the irrevocable trust as to its flexibility and its scope. So again, I mentioned very briefly, older trusts mostly have no built-in flexibility due to no one's fault, just because of when this was done in years past. Trust modification can occur through various ways. The terms of the trust itself can be modified through a non-judicial settlement agreement, decanting, court order, all of these types of things. Where I'm going with that first bullet point there and under trust modification is the terms of the trust itself may provide for enough flexibility that some of these other techniques are not needed. So the very first thing to do is look at older trust or existing trust and see what terms of flexibility are built in, even if it's not obvious, to see if modification could be made without having to use any external device, let's say. So always remember, as we wrap up, our irrevocable trust, just a simple way of thinking about it, is a trust with a special purpose. It satisfies a particular goal or need. And as one person asked as a question, which I thought was very good, if it doesn't really satisfy a goal or need, it may not be needed. It may not satisfy what is called its material purpose. So maybe it needs to be terminated. It provides a certain benefit or protection. It has certain tax aspects. It has flexibility components, hopefully. And if not, it could be built in. And it may have certain control components for the grantor, the person who created the trust. And of course, how the advisory team supports the planning is part of the irrevocable trust concept, that everyone needs to communicate. We need to be at a very high level in this day and time of confusion and upheaval about giving our client the assurance that they need, that everyone on the team is talking and agrees, generally speaking, about the nature of the planning. So what we want to do as advisors is really get ready for the ride that is out there with understanding all of these concepts and giving our clients time to think, working together, some of the things I just mentioned, giving them assurance to make big decisions, keeping them apprised, keeping them in control if that's what they want, reviewing old documents, maintaining family relationships, facilitating planning that actually works because the advisory team and the client are educated and really on the same page. And we like to say that we're here to answer questions. Give us your thoughts, your ideas as advisors or non-advisors on the call here today. We're just here to be a resource. There's nothing to fear. If you're an individual who needs a consultation, there is an attorney-client relationship that arises just because of talking about these things. So there's nothing to fear because you are protected by an attorney-client relationship, even if you don't move forward as a client, as far as we in law are concerned. But for the non-individual, our advisor clients and CPAs that we have on the call here today, or advisors and CPAs, remember that we're here to support you. We want to connect with you again in this post-COVID world, and we want to help you get from point A to point B to help your clients achieve their goals. Jeff, I'm going to stop talking while we're still on time. And I thank everybody for sitting through a very dense discussion, and hopefully you take away some substance from this in your own practices.
Well, thank you, Steve. Some great information and education from one of the great thought leaders about this subject, Steve Elville. Thank you so much, Steve. So now would certainly be your time to get those last questions in for Steve. So please go ahead and get those into me, and I will pose them to Steve right now. So as we wrap up, I'll send out my follow-up email as I always do to everybody, sending out the video and some other supporting materials for you. As far as our webinar series goes, May 16th, new topic, understanding hospice, learning the facts and its many benefits. And then we go to May 25th. We have our advisors forum, which invitations go out tomorrow, understanding the hybrid 5-year trust, one of the most powerful tools in estate planning. And then on the 26th, we have our popular trustee selection workshop, how to choose the right one for you. And we also have many presentations in the area. We're going to see some physicians up in Baltimore to present, and then we have a presentation at a large CCRC in the next few days, so it'll be very busy. If you have an organization or business that you would like us to come out and present for, or do it virtually, we would love to learn about you and see how we can be a resource to you. Just email me or give me a call. Love to talk with you. So let's see if we have any further questions. Okay, one question. Can you repeat the webinar on book recommendations for the non-practitioners on this call?
Oh, okay. I'm sorry. I think I just got the gist of that question. So the book recommendations. Well, I think what I was saying was, if I recall, you could go to our website and learn about special needs planning or other types of planning. You could go to our website and watch all kinds of webinars that are about an hour and 15 minutes long. And so those are free. And we have quite a library there, and Jeff can help you sort through those. You also could go to Elder Law Answers for if your concern is more elder care planning related or special needs planning related, or even a Medicaid trust or 5-year trust related. You could go to Elder Law Answers and probably learn more and see articles about those. So hopefully I'm answering your question properly there.
Yeah, thanks, Steve. I'll send out a link to that information, as well as a link to our YouTube channel. A lot of people still don't know that we have all of our webinars, our entire library is on our YouTube channel for your viewing at any time. So it may be a great resource for you to bookmark, so you can access it quickly. And we're always adding, every one of our presentations is on our YouTube channel and is hopefully a great resource for you, anybody else that you want to point in that direction. So there's some thank yous here, and looks like those are all the questions. So we appreciate you being here on our webinar series today. I hope you found it helpful and useful to your situation. If we can do anything for you, certainly email me or give me a call as always. Reach out to Steve and be happy to be of service to you. So thanks for being part of the webinar series today, and we'll see you again soon. Have a great day.